I'll try and keep this short and sweet. My name is Jon Bartholomew. I've been with the division a little over, two and a half years now. I currently work as the enforcement engineer, the only enforcement engineer for the Division of Water Rights for the state of Utah. It's been great. I've been in the position for about 7-8 months now, but it's a great opportunity to help enforce the waters of Utah. So let's go over a little bit of the history and background of the enforcement program. Something that's kind of interesting to point out is prior to 2005, if somebody was illegally using their water, overusing their water, using it without a water right, we didn't really have a way to regulate that or enforce it. The state engineer had no direct enforcement authority. Persistent violations had to be done in civil court. Some kind of, through criminal complaints or civil litigation. And lacking any civil litigation, violators suffered no penalties at all. Obviously, you've maybe seen examples of this. Maybe your neighbor's been using water and you kind of wondered, are they allowed to use that much? Or people that have been using water. I remember I had one enforcement example where up in Weber County, a recreational center up there, they were literally putting pumps with hoses into the river and watering their soccer fields up there at the county center. And a local resident submitted an enforcement referral saying, I noticed this is going on. Can they do that? And now this resident who submitted this request, I don't think they had done the background research, but I had the opportunity to go in and do that. And sure enough, that's exactly what they were permitted to do. So kind of interesting. All right, so in 2005, sections 73-2, 25 through 27 were adopted to provide the state engineer with enforcement powers, define criminal penalties, and associate costs and fees in civil actions. Additionally, Administrative Rule R655-14 was adopted to detail the procedures for enforcement proceedings. An enforcement action is authorized when a water user, I kind of went over this a little bit, but when a water user is using water without an existing water right or exceeding the conditions for which they are approved. Okay? Examples of exceeding limiting characteristics of an approval. I think you've already heard about what constitutes, say, beneficial use or the aspects of an approved water right, but basically we have a point of diversion, a place from which they are drawing water, be it a well, a surface source, whatever. If that has moved without proper approval, I can step in there. If you change the place of use, maybe it's being used in a different location. Maybe someone claims they have a 1/4 acre of land that they're irrigating, but it's clearly 3 acres. That's overuse. That's something they're probably not approved for per their water right. Or sometimes it's just seasonal use. You might be approved for the irrigation season from, say, April to October, but in November you decide to draw some water. Your neighbor happens to notice, and I happen to step in and take action on that. So, and obviously exceeding the approved quantity of water. These are all instances in which an enforcement action could occur. Might be interesting to point out, there's a lot of weeding I do. Sometimes I'll hear referrals come in where somebody seems to have a problem with someone using water, but either they didn't do the research or they realize it doesn't really pertain to water rights. An enforcement action is not authorized when more than 12 months have passed since the violation ended, or the situation involves private party agreements between water users or internal disputes within water or irrigation companies. Earlier, Cash talked about disputes that might happen. Well, I have these shares and this water company isn't letting me do this. That's something we can't get involved with. That's something that needs to be resolved between the entity and the irrigation company. An enforcement action is also not approved, not authorized when a complaint involves right-of-way or trespass violations. Sometimes even you might have a structure, a point of diversion from which you are drawing water, but you don't own the land on which to get access to that point of diversion, or the head gate, or whatever water-related structure might be on the property, and that doesn't involve us. That's something else you've got to take up with your neighbor, and could involve civil litigation if necessary. After investigating potential violations, efforts are made to resolve violations informally. I will review the referrals that come to me from the public or whoever, and I will reach out to the alleged violator, making them aware that a referral has been made. And if they fail to comply with my demands, that's where I step in and begin an enforcement action formally. The enforcement action begins when the state engineer issues an initial order. That order will include a description of the violation, a notice of potential penalties, and a notice that each day's violation can be treated as a separate violation. Violators may be fined up to $5,000 for each knowing violation, or $1,000 for each violation that is committed unknowingly. A water user may be required to replace up to 200% of the water taken without authorization, and an assessment of expenses incurred by the state engineer for investigating and stopping the violation may also be part of that final order. Okay? Oh, I'm sorry.
So if each day's violation could be treated as a separate violation, could you potentially charge someone $5,000 a day every day that they're in violation of their water right?
They know about it, yes. Obviously, it very much depends on the impact it may cause. The economic impact, how if someone upstream is taking a lot of water and affecting a lot of water users downstream, if it's a surface source, for example, that's sort of the maximum fee. And that it's an administrative fee that can be charged from the state engineer. So, any other questions? I'm sorry, I didn't open up the invitation. Please, I welcome any kind of questions. Let's see, where were we? Some considerations made before actually imposing a fine or ordering replacement could include the value or quantity of the water taken without authorization. The gravity of the violation, including the economic, I realized I just kind of answered this, including the economic impact, injury to other water users. Whether a person is subject to penalties attempted to comply with the order, or the economic benefit to the violator. Most of the time, as I bring these violations to the attention of the alleged violator, they're willing to comply or willing to at least explain their case. Obviously, nobody wants to be fined up to $5,000 a day for each day of violation. So, some goals of the enforcement program. Again, what we're trying to do is encourage the public to help notify us of illegal activity that may be occurring. It is actually not very difficult to find someone that is using water outside of what our database has or what records have for them within their water rights. Someone may file, again, a change application. They have 5 years or whatever in which to prove up on the application. What's the likelihood that they're going to be using that water for the same beneficial uses 5 years down the road? Frequently, what it'll involve as I get involved is I will help educate and tell people what needs to happen. And sometimes it's as simple as file this application, and pending its approval, you'll be good to go. It may be also important to note, as we are encouraging the public to submit these referrals, some might see this as ratting out your neighbor. It's not really it's sort of the case, but Your privacy is protected. The party, the referent, as it were, the one who makes the referral, is their identity is not shared in any way, shape, or form with the alleged violator. So, and I think it's also very important that we take an active approach. I'm just one person trying to make sure that our database is correct, that the water that we have across the state of Utah is being accurately reflected and regulated, and I can only see so much of what's going on. So I welcome the public involvement. Ideally, they've done a bit of research to see if someone is using the water legally, but if you haven't, that's okay. If you bring it to my attention, I can do that research for you.
You got a question?
Yeah.
So let's say there is someone belligerent and fees are assessed. What recourse do you or anyone else have for non-payment? I mean, what's the implication to somebody if they say, "Oh, I got this $5,000 bill. I'm just not going to pay it. I'm going to keep doing what I'm doing." What happens next?
I believe it could go to a criminal court. Do you have any more information on that, maybe, Eric?
Yeah, so I'll verify this in statute, but I'm pretty sure the statute states that their water right will be held and they won't be allowed to use the water right. So it kind of goes into I wish Ross were here to answer this exactly. Maybe Ross is listening online, but there are legal recourses within the statute that will, if they don't pay the fine or if an agreement's not met or reached, then they're in what's the word I'm looking for? Yes, contempt, and so they're not adhering to the rules and statute. So then they are held liable for that, and further action can be taken against them.
I suppose maybe possibly a comparable example you might share is if you don't pay your parking tickets, what's the penalty? So maybe it isn't. Okay, let's see. Oh, obviously we try and resolve any first-time offenses informally, but if there's a second-time offense, we will go to enforcement action. But again, I very much like to take a very active approach. I definitely do encourage the public to submit referrals if they do see some kind of wrongdoing. Also, division staff as well. Anybody can really submit a referral. And that you can actually do that by, the form is located on our applications and records section under miscellaneous forms. There's a link there that will take you to our new online form submittal process. As of about a month ago, it used to be a PDF that you would submit and mail to our office, but now we have an online solution that's much more slick. I think Jim is going to talk a little bit about that when he talks about our webpage tools. So, any other questions? Absolutely. No. The question was, do I send notices to inform somebody, obviously, if there is a violation occurring? Yes. So let me talk a little bit about the process. The public can submit what's called a water rights enforcement referral, and I will create a state engineer administrative action number for that, and I will conduct an investigation. And part of that investigation is a notice of investigation where I will prepare a short document stating a party has submitted this referral, alleging that you have committed these violations pertaining to these water rights, or the more descriptive you can be in your referral, the better, so I can state what has happened. And yes, absolutely. And what I will do is I will give them a period of time, again, kind of depending on the nature of the violation, if it's a lot of water, but to respond to me in how they take this allegation. Frequently people are like, I don't know what you're talking about. I am within my water rights. Obviously, I won't send that notice if I review the referral, I review their water right, and everything seems on the level. I will actually go back to the referent and say they're within their rights of their water right. But if I do notice something isn't copacetic, I send out that notice of investigation and give them a period of time in which to become compliant. You bet. Any other questions? Okay. Thank you so much for your time.